We got a couple of crazy bad decisions involving so-called large capacity magazines, or what are really standard capacity magazines that hold more than 10 rounds, out of Oregon and out of Rhode Island. But it's not all bad news. Let me explain when we get back. Hey folks, I'm Mark Smith, host of the Four Box Designer, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Box Designer Second Amendment channel, please do so and show your love for the right to keep and bear arms. And again, we're desperately trying to get to 100,000 subscribers. Make a big difference for helping us spread the word with the social media algorithms. All right, I'm going to make this a quick one. We're getting occasionally some bad decisions involving the Second Amendment. That is true. Second Circuit, tentative bad decision involving sensitive places, Rhode Island, and a federal district court in Oregon made some terribly poor decisions, in my view, involving so-called large capacity magazines or standard capacity magazines. I think we can ultimately get some of these things fixed. But I want to always give you a little bit of hope, even if we can't. Trust me on this point. The United States Supreme Court is paying close attention to the behaviors of these lower courts. The justices on the Supreme Court are some of the smartest lawyers in America. They're very savvy, very credentialed. They're not dumb. They know what's going on. So when they see lower courts misapplying Nyserpa versus Bruin and Heller in the Second Amendment, they pay attention to this. It may take a little bit of time for this to wind its way through the courts, but they're paying attention closely to what's going on. Now, I bring this up to you to make the following point. That sometimes bad news can give rise to good news. And what do I mean by this? Well, let's step back and think about our great Second Amendment victories and where they came from. Well, Heller versus the District of Columbia came out of the District of Columbia that had banned handguns in the home. So unless D.C. had done that stupid handgun ban, we would not have gotten the powerful precedent of Heller. Likewise, in McDonald versus Chicago, if the city of Chicago had likewise not banned handguns in the city, then the lawsuit against Chicago could not have moved forward. There would not have been one. And because of that, there would not have been, right, had there been no handgun ban in Chicago, there would not have been the Supreme Court precedent of McDonald versus Chicago, which took the Second Amendment's right to keep and bear arms, declared it as a fundamental individual right, and applied to all the states and local governments across the country. Likewise, if the state of Massachusetts, the Commonwealth of Massachusetts, had not been so dumb to ban stun guns, and had the Supreme Court of Massachusetts not taken the absurd position that because stun guns were invented in the 1970s, and thus had not been invented in the late 18th century, they were not protected arms, as in the right of the people to keep and bear arms. Had the state of Massachusetts not taken that position and convicted a woman who used a stun gun to protect herself against an allegedly abusive boyfriend, we would not have gotten the powerful decision of Caetano versus Massachusetts that set the floor for saying that, if a firearm or arm is owned by more than 200,000 people or used by more than 200,000 people in the United States in civilian space, then guess what? It's commonly used and cannot be banned. So without Massachusetts doing what they did, and without the Massachusetts Supreme Court doing what it did, all of which was anti-gun, we would not have gotten that powerful Supreme Court precedent of Caetano versus Massachusetts. And likewise, in New York, had the state of New York actually respected the right to carry guns and issued carry permits properly under a shall issue regime or permitless carry regime, we in the Second Amendment community would not have won, would not have had an opportunity to win. Nyserpa versus Bruin, which set forth a very powerful and favorable methodology for interpreting the Second Amendment and applying it to modern-day gun control laws, which I think is ultimately going to be a fantastic outcome for us. You wait and see. It's already starting. It's going to get better and better and better. You just wait and see. So the point is that even if you see bad outcomes in lower courts, do not lose hope. The Supreme Court is paying attention, and as you saw from Heller, Caetano, McDonald, Bruin, when the bad jurisdictions do bad things to guns and to gun owners and gun rights, the Supreme Court does take notice and uses those teaching moments, those opportunities to take those cases and lay down stronger and stronger Second Amendment precedents in favor of the right to keep and bear arms. Because remember, as I've talked about this on this channel before, the way to think about these legal precedents all across America in support of the right to keep and bear arms, it's like every precedent is another brick in a wall. Every case in favor of the right to keep and bear arms is a brick. So ultimately, when you take these legal precedents and you build them brick, 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 brick upon brick upon brick upon brick, precedent upon precedent upon precedent upon precedent, you eventually build a very long, thick, powerful wall that protects our right to keep, which means to have, and our right to bear, which means to carry firearms here in the United States under the text of the Second Amendment. Okay, so again, bad legal precedents down below often give rise to good legal precedents up above in the Supreme Court, which is the best of them all. That doesn't mean I want to lose any case. I never want to lose a single case. I never want to see a single setback for the Second Amendment's right to keep and bear arms. But even when that occurs, do not lose hope. That is often going to be an impetus for a superior court to make the right decision and set forth a more powerful precedent that ultimately benefits us. Sometimes you need bad news to give rise to good news. Okay, I hope you learned a little bit something here about the legal process and the Second Amendment. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.